All right, good afternoon. This plenary session now turns to the questions of online privacy. And the question we're going to put to our keynote speaker and panelists is, how would things change for U.S. consumers and businesses if the USA adopted Europe's approach to online privacy, such as GDPR and opt-in for targeted advertising, and the European Union's right to be forgotten? I'm Steve DelBianco. I'm president of the online trade association NetChoice, and I'll be moderating a panel of experts to try to answer that question. But first, we're lucky to have Commissioner Noah Phillips of the Federal Trade Commission to set the stage with a keynote address. Now, the FTC, for those of you who don't know, is our nation's top cop when it comes to protecting online consumers and to promote competition on the internet. The FTC has broad enforcement authority over unfair and deceptive trade practices and the narrow rulemaking authority that's granted specifically by Congress, such as in the Children's Online Privacy Protection Act, or COPPA. Now, as the father of 3 young children, Noah tells me he hasn't had a good night's sleep in 7 years and was sort of hoping that COPPA stood for something else, the Children Ought to Give Peace to Their Parents Act. And I think he was disappointed in that regard. Now, before his appointment to the FTC in May of this year, Noah was chief counsel for Senator John Cornyn of Texas for a period of 7 years. He handled antitrust, constitutional law, privacy, fraud, and intellectual property matters. Now, for the Senate Judiciary Committee, Noah also handled more issues of increasing relevance to the internet and internet governance, such as national security, Fourth Amendment concerns, and due process. Prior to his Senate service, Noah was a litigator at major DC and New York law firms, and he's a graduate of Dartmouth with a JD from Stanford. So please join me in welcoming FTC Commissioner Noah Phillips.
Thank you for the kind introduction, Steve. And I'd like to thank IGF USA for hosting me today and for convening policymakers and thought leaders, folks like all of you, to discuss privacy and other critical issues related to internet policy. I also want to give a special thanks to the steering committee members who volunteer their time to make this such a great event. I'm really honored to be here with all of you. Let me begin by saying that my remarks today reflect my views, not necessarily the views of the Federal Trade Commission or any of my fellow commissioners. The FTC enforces both competition and consumer privacy law. So it is inevitable that, in thinking about one, we consider the other. More than inevitable, though, it is essential. When we evaluate changes in privacy law internationally, or consider the whether and how of privacy legislation here in the United States, competition must be part of that discussion. This is a distinct question, by the way, from whether the values associated with privacy ought to bear on antitrust analysis, a topic for another day. I want today to register my concern that laws and regulations intended to promote privacy may build protective moats around large companies, some of which already possess significant amounts of data about people, by making it more difficult for smaller companies to grow, for new companies to enter the market, and for innovation to occur. And I want to insist that competition be part of our conversation about privacy. I'm not alone in this. My good friend Caroline Holland, who's now an advisor to one of my fellow commissioners, wrote recently that, quote, progress on one front, privacy, might lead to regression on the other, end quote. Joe Simons, chairman of the FTC, put it this way in testimony in the House of Representatives just last week. I'm going to paraphrase slightly. Quote, if you do privacy the wrong way, you might end up reducing competition. You might create a situation in which you entrench large tech platforms and make it very difficult for new entrants and smaller firms to get the attention of the consumers that they're trying to reach, end quote. If our concern is warranted, the questions for proponents of new privacy rules then must include, are we willing to allow a reduction in competition or innovation? What competitive price Are we willing to pay for greater privacy protection? Are we willing, for instance, to allow the biggest technology companies, lately the focal points of discussion about both privacy and competition, to entrench further? I suspect that this audience is already familiar with the various privacy and data security rules that apply in the United States. But for those who may read this speech later, both of you, I want to set the stage. The FTC has long been the federal agency with primary responsibility for and experience in privacy policy and enforcement. It's been 20 years since our first major online privacy case against a company called GeoCities. So I want to do a little experiment. Raise your hand if you remember, like, actually using GeoCities. Okay. For those who don't, when I was in college, it was a popular web hosting service and one of the most common sites that users would go to in order to access the World Wide Web. In 1999, the year after the FTC sued, GeoCities sold to Yahoo, which was then a dominant player in search. I think that all tells you a little bit about the history of competition on the internet and in search. At any rate, 20 years ago, the FTC sued GeoCities for engaging in, quote, deceptive practices in connection with its collection and use of personal identifying information, PII, from consumers, including, among other things, falsely telling users that their PII would only be used to provide them with the advertising, offers, or products and services that they requested, when in fact, GeoCities sold that information to third parties. The FTC brought the GeoCities privacy suit nearly 30 years after passage of one of the nation's first and most foremost and significant data privacy laws, the Fair Credit Reporting Act, which, among other things, regulates the sharing of consumer information by credit bureaus. As the Supreme Court explained, FCRA, as we call it, was passed for the dual goals of, quote, promoting efficiency in the nation's banking system and protecting consumer privacy, end quote. And since then, as Steve alluded to, Congress has passed an array of privacy and data security laws and has directed the FTC and other federal agencies to develop a host of new rules, including updates to FCRA itself, governing the collection, use, sharing, and security of personal information. COPPA, and I did not come up with the other acronym, COPPA is another example. I won't bore you with a recitation of every privacy statute and rule that we enforce, but the point is, we have significant enforcement authority across a variety of commercial privacy areas. And other federal agencies enforce other privacy laws, such as HIPAA, which is the reason you spend so much time at the doctor's office not seeing your doctor. This is all not an accident of history, as some would have you believe. When you step back, what becomes clear is that we in the US have a principled, risk-based approach that focuses privacy and security rules on the sectors of the economy where Congress has determined such rules are most needed. Even within those sectors, our approach recognizes that all entities are not the same, and in many cases, the law explicitly permits different types of protection based on the size of the entity, the data being protected, and the like. The United States risk-based approach imposes the greatest costs on businesses at the points where our democratic process has determined the greatest privacy need exists, limiting such costs where the need is less. So, while we may argue about whether the risks are being appropriately evaluated, whether, quote unquote, leveling the playing field among firms doing different things with different kinds of data makes sense, or whether the quality and quantity of data being collected today ought to change our approach, we should not be confused about whether the American approach to privacy is deliberate or sensible. The American approach stands in contrast to the privacy regime now in place in Europe, and the one set to become effective in California in 2020. Fundamentally, these regimes require everybody to adhere to one set of standards and one set of costs that apply to all online entities, regardless of size, regardless of service, and regardless of risk. What might be the cost of such an approach to privacy? By their nature, regulatory regimes create compliance costs that are durable and may become more onerous over time. These are what economists call economies of scale, costs that large companies can bear more easily than their smaller competitors or new entrants. Don't take it from me. As Mark Zuckerberg told Congress recently, quote, "I think a lot of times regulation, by definition, puts in place rules that a company that is larger, that has resources like ours, can easily comply with. But that might be more difficult for a smaller startup to comply with," end quote. I should note that, in the same testimony, he signaled his openness to additional regulation. While we may want to protect privacy in new ways, and that is a reasonable question, we do not want the regulatory burden to be so onerous that it excludes potential market entrants or inhibits innovation. At the very least, we need to have an honest conversation about the costs and the benefits. Take the General Data Protection Regulation, GDPR, the new European privacy law. For Europeans, it represents an expression in law of their view that the protection of personal data is a fundamental right, nothing less. For the US, it may provide a test case for how a different privacy regime than ours might work. My concern is that early signs point to precisely the effects on competition that I fear. According to the Wall Street Journal, when the European Union's Justice Commissioner met with the large technology companies prior to implementation, instead of hearing the complaints she reportedly expected, the companies told her that they would be compliant. She explained, quote, "They have the money, an army of lawyers, an army of technicians, and so on," end quote. Facebook, for example, mobilized hundreds of people in what it described as the largest interdepartmental team it had ever assembled. Jedediah Yue wrote in Forbes, quote, "Ironically, big tech companies such as Facebook, Amazon, Apple, and Google benefit from a silver lining when it comes to being regulated. What hurts their competitors more only makes them stronger," end quote. That's not ironic. That's economic. Exactly how economies of scale work. Resources devoted to compliance can be scaled, and they could have been spent on innovation or wages and so forth. But beyond standard economies of scale, privacy rules in particular may skew to benefit large incumbents. Consider requiring affirmative consent and assume that consumers are, as maybe we want them to, considering the question and being selective with whom they share their information. Consumers are more likely to trust companies that they know. This is an application of what economists call brand effect. And to the extent large incumbents also provide popular services, for instance, as a result of the network effects endemic in certain technology markets, the big guys may win again. On May 25th, the date GDPR went live, the Wall Street Journal reported that some digital advertising, ad tech, companies, relatively small competitors to the large technology companies that dominate online advertising, decided to stop advertising in Europe due to the consent requirement. Advertisers, according to the journal, quote, "were planning to shift money away from smaller providers and toward Google and Facebook," end quote. Bill Simmons, the co-founder and chief technology officer of Dataxu, a Boston-based ad tech company, noted the paradox, quote, "GDPR is actually consolidating the control of consumer data onto these tech giants," end quote. Snap's CEO also has recognized this point about GDPR, stating, quote, "There are times in history when regulation has actually entrenched big companies because they're the most capable of complying. I think that's a huge mistake because I think that would inhibit innovation," end quote. There's also another, more insidious effect that any regulatory regime can have. Large companies can manipulate legal requirements to their own benefit more easily than smaller competitors or new entrants. Public choice theory teaches us that the durability of legislative and regulatory barriers to entry is one of the reasons that incumbents find it attractive to spend resources on securing legislation and regulation that insulate them from competition. But the benefit to incumbents is not just lobbying for laws that favor them. It is also implementing seemingly neutral rules or regulations in ways that benefit them at the expense of their would-be competitors. Just to be clear, I don't think this is behind GDPR. I don't think it's behind California's law or anything that Congress might consider. But it does happen, and it should concern us. I'm also concerned, of course, about stifling innovation. Several papers have analyzed the effect of state privacy laws on the adoption of electronic medical records, EMRs, which not only make the exchange of information more efficient, but can lead to improvements in the quality of care. The authors of these studies find that these laws, quote, significantly reduce the adoption of EMRs, end quote. Evidence that privacy regulations have inhibited the proliferation of innovative technologies that benefit consumers, in this case, patients. And if the healthcare analogy holds, a poorly designed national privacy regime could impose higher compliance costs across the economy, hindering innovation and again increasing barriers to entry. Finally, we may still face other unintended consequences. To go back to Mr. Zuckerberg, he recently noted, quote, I think that the alternative to the big US technology companies, frankly, is going to be the Chinese companies, end quote. It's my understanding from Twitter that Stuart Baker made a similar point here today. Chinese tech competition is real. Indeed, it is China's national industrial policy, and it may pose more than just a competitive threat. This is something that the ranking Democrat on the Senate Select Committee on Intelligence, Mark Warner, has also recognized. The upshot is, as we consider the potential benefits of new privacy protection, we must consider the cost too, on competition, innovation, and other things. GDPR provides us with a great opportunity to see how a large-scale privacy regime works in practice, and for us in the United States to learn from Europe's experience. We do not yet know the answer. But about the American risk-based approach, however, we can say one thing for certain already. It has both targeted the areas of greatest privacy need and still permitted a tremendous amount of competition and innovation. The upcoming hearings hosted by the FTC will also provide a good opportunity to discuss the important topic of how privacy is related to competition and innovation. I invite everyone here to join and weigh in with comments and proposals for those hearings. Thank you all very much.
Thank you, Commissioner Phillips. Your remarks are definitely going to help to guide our discussion on how we in America should respond to the EU's new, colonialism over our nation's privacy regulation. And I wore my USA flag tie today to help remind our panelists this is not the Internet Governance Forum Global, this is the IGF USA. So I'll wave the flag whenever we need to. On our panel, we have an outstanding set of experts who have different perspectives on this. Let me start on your left. Joe Jerome is Policy Counsel at CDT, the Center for Democracy and Technology, where he focuses on legal and ethical questions raised by smart tech and big data. Prior to CDT, Joe was an associate in the cybersecurity and privacy practice of a major law firm covering ad tech and privacy compliance in the health and finance sectors, which Commissioner Phillips talked about. Next to Joe is Amie Stepanovich. Amie is the U.S. Policy Manager at Access Now, where she ensures that surveillance and cybersecurity laws respect human rights. And previously, Amie directed the Domestic Surveillance Project for the Electronic Privacy Information Center. Next, we have Grant Nelson, who's counsel for the Network Advertising Initiative, or NAI, where Grant does annual privacy reviews of every NAI member company. You're going to be busy this year, Grant. Fun fact is that Grant founded a tech charity that gives food pantries the excess and leftover food that comes out of banquets and restaurants. So the excess alcohol from the cocktail party that follow here is going to go straight to Grant. And our fourth panelist is Berin Szoka, who's president of TechFreedom. They are the leading edge on the hardest policy and legal questions that are raised by technological change in the United States. Just ask anyone who's opposed Berin in a debate or a hearing. Previously, Berin sharpened that edge at the Center for Internet Freedom, and then prior to that at the Progress and Freedom Foundation, and in the communications law practice at Latham and Watkins. Fun fact about Berin is that today is his birthday. 28. So let's tee up some questions for this panel. As Commissioner Phillips set the table for us, the U.S. approach has been strong, opt-in privacy protections for data that can cause harm, risk-based, for financial and medical purposes. But opt-out in the U.S. has been the rule for data that's used for targeted marketing and advertising purposes. And that is how, I would stipulate, that is how America's online software services have been free to users and how they have come to be dominant and embraced around the world. But if we reduce the targeted advertising economic opportunity, I think that revenue decline means that users will either see more ads, they'll see less relevant ads for sure, there'll be more sites that will have to put up paywalls or charge subscriptions, and finally sites will have less revenue to pay to create new content or to provide new services. So the first question, and we'll start with Joe and work your way down. As a general principle, how should the U.S. states, Congress, and regulators respond to the EU's cross-border approach with GDPR and opt-in? You might consider, do we want to harmonize with the EU? Should we maintain our historical approach, or is there a third way you have in mind? Joe.
I think there's a lot to unpack there, and I look forward to having a back and forth about ad tech momentarily. I suppose I should say, first and foremost, CDT has long espoused the need for a baseline federal privacy law, and we are far behind the 8 ball on this at this point. There isn't a third way. We are already being left behind. Commissioner Phillips mentioned that it's basically us against the EU. I would also add it's India working on a data protection regime, Japan just having an adequacy agreement with the EU, and a whole host of other countries that have data protection laws. And still, we wish to sort of stay here and say we're going to offer an alternative approach. Our alternative approach has been to do nothing, and we're being sort of left in our wake. And it isn't just the GDPR. There's a lot happening at the state level that I think we'll get into that reflects a democratic desire for privacy laws. I think we'll focus a lot on what's happening in California, but just in the past year, we saw a data broker bill passed in Vermont, which has new restrictions and transparency requirements on data brokers. We shouldn't forget that Illinois has a really vigorous biometric privacy law that really seems especially timely in light of recent stories, Microsoft's call for basically a broad discussion about what to do about these sorts of technologies. And so all of these things are already here. And instead of proactively having a conversation, industry has spent the past 20 years fighting against each and every one of these things. And my response is, it's clear that there is a popular interest and a democratic impulse for privacy laws. Instead of saying, well, let's just keep having further conversations, it's time to put pen to paper and put some ideas out there. And it has to be meaningful legislation. At the end of the day, I think companies are calling for certainty and flexibility. That seemed to be the impulse of a lot of the comments the commissioner just made. And that seems to, again, call for a grant of authority to the Federal Trade Commission to do some regulation in the areas that require a specific demand. Instead, we've had 20 years of the FTC trying to do common law of privacy through consent decrees, which I imagine other people on the panel are going to say was a bad approach. And again, that sort of calls for the need for actual legislative language. The time is now, folks.
Thank you, Joe. We're going to bounce now to Grant. We're going to go over to Grant, then to Amie, then to Berin. Grant.
Thanks. So if the last 20 years of American tech company progress is considered leaving us behind, I'm all for it. The European approach is probably going to play out to prove that the economic incentives that you set up, companies will adapt to. If you create an incentive structure that makes it much harder for someone to start a new company, for someone to create a product that is free and will hopefully be ad-supported, it's going to be far harder for you to find a venture capitalist willing to back that, to take it to market, to create something that's free for people to use if there's zero chance that you're able to monetize it down the road. If the approach of self-regulation, which as a self-regulatory body the NAI is clearly a fan of, if that's considered a failed third way, then I think you got to check your facts. The approach of the NAI has been pretty strong. We've gone after companies. We make companies make a substantial number of improvements every year to their privacy policies, to their practices, how they collect data. Additionally, if a company is collecting data for targeted advertising purposes and they're an NAI member, we have strong restraints on what they're allowed to do with that data. So most of the harms, that is the harm-based approach, the NAI has listened and we're adopting that for, I don't know, 20 years now.
Great. Thank you. Amie.
So there's a question of if, oh, I did not flip it on. Sorry, I was so busy trying to respond to you guys. I didn't want you to hear what I had to say. There's this question of if the US should follow in the EU's lead or not and stick with where it is. I actually do think there's a third approach because we should be implementing a baseline data protection law in the United States, but it shouldn't necessarily be the GDPR. The GDPR in Europe has a long history of case law, of interpretations, of decisions that provide a really robust structure that the GDPR fit into. And in fact, a lot in the GDPR is not new. Most of the rights were contained in the Data Protection Directive before it. They just weren't complied with because there was no real motivation for them to do that. These were all things that companies should have been doing in Europe for a really long time and we're ignoring. The approach I think we should take in the US is to learn from the EU approach, but to adopt an approach that makes sense in the United States. And so we put forward a list of things that we think should be in a data protection law at the federal level, baseline, apply to everybody. One of the things that we have in that list, in addition to rights, many of which are in the GDPR, but not all of which, is incentives for companies to explore and produce business models that are not necessarily based on data. Because we kind of came to this point where, yes, data drives the internet economy. Does it have to? We don't know. We know there are large amounts of companies set up that collect large numbers of companies set up that collect large amounts of data just because there's this assumption that they're going to make money off of it at some point. Some of them don't even have a thought of how they are going to make money off of that data someday. They're bringing it in. They know that data, there's this notion that data drives the internet. If companies had a financial incentive to explore other business models, we might be able to come up with something more inventive. And I think if we want to have an internet economy in the United States based on innovation, we need to embrace that there is innovation out there about how to make money online as well. And so there is a third approach. It is potentially like the GDPR in that it applies across the internet, but I don't think we need to adopt the GDPR here, and I don't think we should be discussing that. We should be talking about what makes sense here, and that is specific rights that apply to everybody. It's not necessarily leveling the playing field between companies. Let's level the playing field between users so that people can't afford to get privacy if they come from more privileged backgrounds and are left without any protections if they don't come from those privileged backgrounds.
Thank you, Amie. The notion of learn from experience is a welcome idea, although that would require that we wait for some experience to actually happen, that we wait for the new compliance regime, which kicked in May, to have its effect, both intended and unintended, on the American-led business models and risk base. So learn from experience doesn't mean just let's see what European companies have done for the past 6 years under GDPR, but what does it do to the American business models of online? I'll be interested to see whether we can explore what you meant by learn by experience. But first we'll go to Berin Szoka.
So I doubt any American in this room admires or enjoys life in Europe more than I do. Put me in a group of French pensioners or school children touring any archaeological site in Europe, and I'm just as happy as can be. But I think we also have to acknowledge that Europe has not distinguished itself in leading the way in developing internet services. And this is not because Europeans are not brilliant, creative people. They are. I speak French very often when I go to San Francisco. It's everywhere on the streets, as is German, many other European languages. The United States has created a place where people who want to innovate and develop those services go. That place does not exist in Europe, and the reason is there are many reasons for it. It is not simply because of privacy regulation. It also has a lot to do with the labor market, the tax environment, business formation, et cetera. But the lifeblood of the internet economy, even more than advertising, is data. It's what these services are built on, not just to monetize, but but to connect one service to another, to allow you to pull up your calendar in an app. All the things that we do every day on our phones require that data is used seamlessly. And the European approach to privacy regulation is utterly antithetical to that. So it is not surprising that, as the question was asked earlier, how many European tech companies can we think of? I love Spotify, and I used to use Skype. And that's it for me, personally. There are, of course, others. I don't mean to diminish them, but the United States has had a great success story, and the freedom to use, to innovate data without permission has been a big part of that. And it's more simple, it's more complicated, excuse me, than opt-in or opt-out. But if you boil it down to that's a pretty good first approximation of how this works. And I think the US approach fundamentally is the right one. Now, I don't think it's perfect, and I don't think it's going to stay exactly as it is. So I don't think that we can pretend that there won't be further legislation. I think it would be unproductive to avoid talking about that. But I think where Amie's quite right is not just that we shouldn't take GDPR off the shelf, but literally that we can't. No matter how much you might like the GDPR, it is not developed for the United States legal system. It takes into account in no respect the First Amendment. GDPR covers all information, and in the United States, a lot of that information will receive the highest form of First Amendment protection. Even though the purely commercial speech still receives First Amendment protection in the United States in a way that does not exist in Europe. So if you were to start from ground zero and you were to ask yourself, what lesson could we learn from GDPR? What should the United States do? You would inevitably wind up with a completely different framework, one, because of the First Amendment, and two, because of other basic American principles about due process and constitutionally required fair notice and clarity about what the law is supposed to tell you before you can be penalized, and regulatory takings and so on and so forth. But the second major difference, and Amie alluded to this, yeah, a lot of the things in GDPR are not new. A lot of them have been legal requirements in Europe for a long time, but as she said, have essentially been ignored. Well, why is that? It's because the enforcement reality in Europe is fundamentally different. In the United States, laws, when written, they get enforced because we have a different legal environment, because we have aggressive regulatory agencies that pursue companies and enforce laws as written, and are not simply exerting their prosecutorial discretion to ensure that unworkable laws are not carried to their logical necessary conclusion. Right? That's what the DPAs in Europe have essentially done for the most part until now. And there's one final large important difference, which is that, yes, there are private rights of action under the GDPR, but if you were to take that in the United States and combine that with the US system of class certification, you would have a completely different outcome, because we have a well-developed trial plaintiff bar that is designed to take legal rights that are given to individuals and magnify them to the point of reaching enormous damages. So you can't take the GDPR as a starting place. You need to develop an American-based approach. And I'll just close by saying that the Obama administration, to its credit, tried to do that. They developed, as everyone here knows, principles in 2012 that I think were in many ways a good distillation of an American approach to privacy. It's not exactly how I would have written them if I'd done it myself, but I don't fundamentally disagree with what they did. The question is about operationalization and what the legal mechanisms are to enforce those. And now that this current administration, the NTIA, is starting to take comment on what the US approach should be, I think the most important thing is on enforcement, on penalties, on who has legal rights, how they're brought to bear in the courts, what the role of the agency is. These are all questions that, in some ways, the Obama administration tried to push to the private sector, tried to encourage private organizations, whether they be civil society groups or multi-stakeholder groups or industry standard setting groups, to deal with. I think that's fundamentally the right approach, because as the Obama policy noted, it's a mistake to think that the government can develop a one-size solution for these problems. We need, in general, for internet governance, we need, as we always have had in multi-stakeholder formats, a variety of approaches for a variety of different problems.
In the interest of equal time for alternate perspectives, Joe or Amie like to respond?
Well, I would only add that I feel like the history of privacy multi-stakeholder efforts in the United States is one of abject failure. Absent an enforcement stick or a penalty stick, we saw industry basically slow walk and agree to nothing.
Yeah, but just to be clear, what I'm talking about is as the Obama administration proposed, you can have a model where you give people a legal incentive to do it. You say, here are the requirements, and we will let you go develop a safe harbor, and then we'll talk about it. I'm not simply saying we let the market work it out. I'm saying there should be a dialogue between government and those other bodies that may come up with
that doesn't work until you have a firm baseline in place to actually bring companies to the table. My argument would be that self-regulation in the United States, I mean, when it comes to privacy, it doesn't actually give any sort of substantial rights to individuals, which is something I think Amie's concerned about, and it defaults over and over again to just providing more transparency through privacy policies. And this sort of transparency is supposed to be the thing that alleviates the harms here. And I think from our perspective, we look at ubiquitous data collection. I understand permissionless innovation has been a wonderful thing in the United States, but it comes with costs, and it comes with costs that impact people's autonomy, their individual agency, and over again when we talk about this harm or risk-based approach, it's so narrow-minded and focused on a narrow sliver of physical and financial harms that it eliminates things that I think are serious concerns to individuals.
And Joe, you used the expression in your two interventions that the U.S. can't continue to do nothing, and then you said that our entire approach has been an abject failure.
Well,
so
that's
with that,
perhaps a bit
Frank,
boisterous on my part.
well, I believe so, because I wish Commissioner Phillips were still here and would reel off the list of cases the FTC has brought. And the U.S. focuses on harms without apology. And that harms-based approach without apology says we spend a lot less attention to things that don't have consumer harm. Now, you may believe that once I've established that you have a right, then any diminution of that right is inherently harm. From that perspective, I can see where you are completely unsatisfied with the U.S. approach. But it's going to be incumbent on all of us to maybe depart from the rhetoric and get down to the reality here of consumer benefits and consumer harms. Amie?
So, my name's been used a lot by people on either side of me, so I'm going to go ahead and interject. I think first, before I respond to that, there's an important point here that I think Berin brought to light, is how much we agree on. Some of this panel is like, should there be more privacy in the United States? I think even people who don't necessarily want there to be recognize that we have reached a point where there is going to be an additional data protection law, regulation, something that goes in place in the federal level in the US. And in fact, companies are now pushing for it because they're seeing California,
Patchwork.
They're seeing potential action in New York and in other states as creating even more burdensome needs for them to act in different states. So we're there. Now we're just fighting about what that looks like. So, and I think that's really important because this conversation actually starts the step before that. And if we can take that together as a room, take that step forward and say, what are we looking at, not are we looking at something, that impacts the debate.
It does, but if the driver for national legislation is to overcome and preempt a patchwork of inconsistent state laws and private right of action, then that's federal action. It's driven by the need to counter really dumb actions in the states. It's not because of some fundamental need in the hearts and minds of every American that we need more rights to privacy.
I think a lot of Californians would object to you calling their new law dumb.
Well, it is dumb. No, it is, hold on. It is dumb. When you write a 10,000-word law because someone, in a matter of, a few weeks, because some wealthy businessman essentially put a gun to the head of the legislature and said, if you don't,
There was much less clapping to that.
If you don't write something, no, hold on a second. This has nothing to do with privacy. This is just a matter of the democratic process. Right? That's an insane way to regulate the entire internet. To say we're going to put our crazy quilt idea out to the voters who cannot possibly understand something so complicated, right? An initiative process is not appropriate for that kind of legislation, right? Which is effectively what that is. And by the way, we're going to use that to amend the Constitution so that it can't be fixed unless you just go out and write something in the legislative process, which a number of legal academics have looked at it and have noted in many respects is riddled with errors, is inconsistent, is poorly drafted. So I don't know what else you call that, but dumb. Now that's not to say there couldn't be smart laws, but no one, I hope, is going to defend that as a serious effort to deal well with privacy. So what we should be doing here is avoiding legislation by having a gun to our head. And I'm happy to talk in detail about what that should look like. I am by no means saying that we shouldn't change the current U.S.
California
approach.
and the GDPR are the gun to the head. Absent these two things, we'd be continuing on a status quo of do nothing.
Right, you're making my point, Joe, is that we're being driven by other laws that have a completely unappetizing effect and unrealistic effect on the American business model.
But
We're not
those
being
laws
driven by a need
themselves-
for privacy.
Those laws themselves were driven by total inaction, not only inaction, but pressure against action by major companies, both at the federal and state level, for 2 decades, which Joe pointed out. Once you reach a certain point where they're looking at a data breach every single week. They're looking at Facebook Cambridge Analytica, which is, by the way, harm in the name of manipulation of users in advertising. So it's not the harm, the financial harm that you guys are talking about when you talk about harm-based approach, but there is harm there.
So can we talk about data breach for just a second?
One second first. Let's see if we can segue, Berin, to this notion of which data we're talking about. It's the question we had presented earlier, is that how should the U.S., both normatively and what we have to do in terms of being driven by reality of GDPR, how should we define personal information that has to be regulated? This is a sea change for us because we have typically regulated personally identifiable information, and Commissioner Phillips talked about. But the EU, and Joe, now California, regulate personal information of any kind that could potentially be linked to a person or even to a device and not a person. So the scope of regulation of what we'll regulate is, under the GDPR and California approach, all data. And I think you'll concede that my shoe size doesn't carry nearly as much risk as my social security number, and that there ought to be maybe a sliding scale of, well, risk-based, dare I say it, risk-based attention to data, or do you believe that all personal information should be regulated?
I'll
Joe?
jump in first, I guess I would push back on the notion that we've only just regulated PII. We've only just regulated PII in the context of ad tech. We have other sectoral laws that have much broader definitions of
Other
what
sectoral
constitutes-
laws that you said have been an abject failure and a do-nothing.
I didn't call the other sectoral laws an abject failure. I've called our generalized approach to privacy an abject failure. So I look at HIPAA and see plenty of good things there, but then I see a tremendous gap. So there's plenty of data that then falls out of HIPAA. So to pivot back to what I was going to say, there are plenty of laws that have broader definitions of PII. And I think there's something to your point of a spectrum. I think that's difficult to legislate, but I also think we have to acknowledge that, and I think we're maybe as a panel going to have to agree to disagree, that we're not going to agree on what is sensitive. I think it's my contention that sensitivity is in the eye of the beholder. The NAI will trumpet the fact that they have, pretty progressive thoughts on what should be sensitive information in advertising.
We're
of course,
accepting suggestions every day.
well, except for the fact that I'd quibble that we still don't have consensus on certain things. So what constitutes precise geolocation? We all might acknowledge that health information should be considered sensitive, but certainly under the NIA code, I imagine targeting pregnant women for various types of stuff, autism tests, that isn't covered. That's not sensitive. To me, if my spouse was pregnant and being targeted with ads for various things, that might unnerve me. So we have to have a conversation about both sensitivity, but then also I think we also have to acknowledge that all information is sensitive, and a data protection framework needs to acknowledge that all data, companies have a responsibility to be good stewards of all data. Now, what that stewardship requires should be flexible.
Berin and then
Yeah,
Grant?
so I think the point you're trying to make, Steve, is that you don't serve privacy interests well if you treat all data as equally sensitive. And I think the point, I think you agree with this on some level, Joe, but the question is how you operationalize this, right? So if you end up saying all data has to be subject to standards of stewardship, you fail to incentivize companies to devote resources where they're most needed. And the example, I think sensitivity is not the place to start. Let me give you a better starting place for this, which is, let's just talk just for a second about what is actually within the scope of GDPR. Now, I'm not a GDPR expert, so I'll paraphrase this as I understand it.
Nobody is.
Well, no, indeed, nobody is, right? Because it's not as if this is it's not even a finished law. There's a lot of stuff that's still going to be either subject to enormous discretion in its implementation, or that still has to be dealt with by the national legislatures. But there's one part of this that's at least to some extent clear, which is that there's a distinction drawn in GDPR between anonymization of information, which is to say making it impossible to ever identify anyone with that information. If you're able to do that, then it's outside the scope of the GDPR period, versus de-identifying the information, which is, again, I'm paraphrasing here, but is essentially, it means to reduce the likelihood that someone could potentially re-identify it using other pieces of information. Now, obviously that's true, right? Of course, there's always going to be a possibility for certain classes of information that you could re-identify. The problem is, I don't know of any guidance given, I've done some research on this, as to what that means. And if you don't give any guidance on that point, and if you don't therefore give any incentive to companies to try to de-identify data, you can wind up with some really perverse results from the perspective, not of business, but of privacy advocates, where you could say to companies, well, it's all or nothing, and you either take it out completely of the realm of GDPR, or don't bother trying to de-identify it. Just keep it basically with all of the attributes in that form. And so that's one very important example of where failing to do risk-based assessment or to weigh trade-offs or to think about incentives may end up actually producing a scenario where you hold a lot more data, or at least the big companies that are able to navigate the system and able to get consent are able to do so. That can't be a good thing for the competitive landscape or for privacy interests.
Amie?
So I think Berin has a point here. If we were only looking at exactly what Berin is looking at. The problem is there are other incentives that companies have in order to do things to minimize the risk to data. One of those is in the security space. So we're talking here about the privacy space. But there are other incentives for companies to make sure that data is secure, and that if somebody breaches that data, that it is as minimally invasive to their user as possible. So even if it is anonymization or nothing, and the company chooses to do nothing, and then they suffer a data breach, that is an issue. So they have further incentives to actually take actions to protect data internally, other than just the privacy regulations. And so these things operate together. We have to look at them together. We can't say, you're not creating any incentive to go halfway or to do some things, because those exist in other places.
That's fair, but my point
give
stands
Grant a
about not
chance.
providing guidance.
Yeah, let's
Yeah,
give Grant a
very
chance.
few companies are out there saying we don't have very important data, so we're not investing in security. They all spend a fair amount of money on security. No matter what data you have, you don't want your competitors finding it. The companies I work with, how about that? What I've seen across the industry is when you have an incentive structure that says all data is the same, whether it be a social security number or some observation about their shoe size, they say, well, what the heck, we might as well collect everything, spend $10 more on whatever security service we use, and just collect everything and get consent for everything. And I think that sets up the incentive structure that we all seek to avoid in terms of companies that should have a low barrier to entry to start doing things in the space. And as they get more competent, more funds, get bigger, they start to do the more and more interesting things that require more trust, more investment in security, more investment in privacy programs. And I think to say something very nice about the GDPR, I think that's one thing the GDPR attempted to get right that I think California just totally missed the ballot on.
So there's one more point on
Ballot.
sensitivity
Missed
of
the boat.
data. NIST, a year and a half ago now, put out a report on privacy engineering that, if I'm not mistaken, they're looking at doing more with. There's a really important provision in that report because they talked about who you should evaluate the sensitivity to data based on, or the risk to data based on. And traditionally, we've always looked at the risk to the company because that is generalizable. You can see when there's a lawsuit that can be brought, what harm is to the company, where there's regulation. The risk to the user is different. And so, for example, companies put a great deal of time securing credit card information because there's a lot of requirements to protect financial data. There are requirements to notify people if financial data is breached in some way. There's a lot of incentive there. But I have talked a lot to people about this, and a lot of the sensitivity that people hold isn't on credit card data. If my credit card gets breached, I know how to call the credit card company. I know how to cancel the credit card. I know where my recurring payments are. I know that I got that process down. If the searches in my Amazon Echo get breached, or the activity on my Fitbit gets breached. Like the non-financial data that companies don't have the incentives, I don't know how to handle that necessarily. I don't know what harms come from it. I don't know how to mitigate it. If the photos on my phone get breached, I don't know what to do to mitigate harm for my photos. And so I think that movement from risk to the company to risk to the user is going to be really important. We haven't seen that shift happen yet, but at least we've seen it recognized in that NIST report. The other point is, this is a really white panel. Risk needs to be evaluated from the people who are most at risk, most marginalized, and so you can't have this conversation and think that we're going to get an end to it here. Yeah. We have to go out and talk to other people, because this is not, we are not the people who are most at risk ever online. They're not on this stage.
Well, I will beg to differ in one respect. I mean, growing up as a closeted gay man, I do very much appreciate the extreme sensitivity of data and the very real privacy risks that, think about millions of gay teenagers across America of all colors. I get it. I mean, I really don't need to be reminded that there is a diversity of sensitivity of information. And when I defend the US approach, I'm not saying it's perfect, and nor am I saying that the only risks that matter are financial risks. I think rather, if you look at the FTC's history of using its existing authority, you'll see that they've actually been pretty aggressive at, for example, when XY Magazine, which was targeted towards gay teens, when they were in bankruptcy and up for sale, the Federal Trade Commission intervened to make sure that their customer list didn't get sold. Okay, so the current approach in the United States is a lot more, if you will, woke than one might think. Now, we can talk about systematizing it, okay? You might say that we need to have a more consistent approach to doing that. But it would not be fair to say that the United States is only focused with what happens to your credit card number or your social security number. And when I said earlier that the Obama administration did a pretty good job of summarizing the principles of American privacy law, that's the kind of thing I was referring to. The question is, again, how do we operationalize them? And I don't think that either the California approach, which is very rushed and not well conceived, nor the European approach, which was not drafted for the US context, will work. In that sense, yes, to answer your first question, there has to be a third way, indisputably, to address these issues.
And meanwhile, though, we will have to find a way for companies to comply with GDPR, since it already applies to US companies serving Europeans, whether those Europeans are on the continent of Europe or here in Washington, D.C. So there will be opportunities for European regulators to bring these data protection authority actions. So we will get to learn from experience as cases are brought. I wanted to turn next to what Commissioner Noah Phillips really focused his remarks on. We've already talked about the notion of harms-based versus broad, but he also suggested that whatever regulatory approach is taken in Europe or here, that we have to be so careful to competitive concerns, that regulatory barriers like that, Europe's approach on preferring opt-in, and this will give you, Joe, a chance to answer what I put to you the very first, because an opt-in regime is injurious to startups who are not going to be able to get an opt-in consent to anywhere the same degree that an established company that people already know. So I wonder how, under an opt-in regime, we could have built the American internet economy we have today. Joe?
So I guess first, and I can already see the response though, is when this single-minded fixation on opt-in versus opt-out consent. The GDPR isn't all about consent. There are other legal grounds for processing in the GDPR, which are always lost in conversations here in the United States, because this opt-in, opt-out distinction is almost exclusively the domain of advertising. So I always have to remind people, and I've done this before, to say, every time people say innovation in these conversations, do they mean actual innovation, better education, smart homes, smart cities, or are they just talking about some new advertising technology? Because I think you need to split those two. Not to say that advertising is
Would you concede that search, connectivity, social networks, content, these are all valuable services, Joe. They're not advertising. But if they're funded by advertising, I'm just going to ask you, please, to connect the fact that many of the things that you use in your daily life that are free are funded by advertising.
Well, I mean, most of the, I've willingly opted out of many of these things, so I'm not using a lot of them in my daily life. I will concede that a lot of these things have tremendous utility. That said, again, I want to push back on the notion of yes, Google is ad funded and does a lot of stuff, but then what are these other awesome, innovative advertising services you're talking about? I just don't know what they are. But my bigger issue here is this, again, single-minded fixation on opt-in and opt-out. What I think is really important about the GDPR is it also has a whole lot of components that are about increasing accountability within organizations. And what I really think we need to do is find out a way, and Grant was getting at this a little bit, is to ensure that companies are thinking about and caring about these things from day one. Just because you're a startup doesn't mean you should be cavalier about privacy until you have X number of users or get into X type of data. Now, I realize that that's a tough ask to make, but at the same time, I think the goal is to put sort of skin in the game. So, one of our proposals has been we'd like to see companies, instead of dumping information into privacy policies that no one reads and that can be twisted and created, it's just a bunch of legalese, to do things that are akin to sort of like SEC disclosures, where CEOs are testifying to the fact that they were considering these certain types of risks. And I actually think Amy's totally on point that the risks shouldn't necessarily just be to the company and to the growth, but the risks to their users and to their individuals. And I think that's the type of maybe forward-looking way that the US
Berin or
can
Grant, and
address
then we'll go to
privacy.
Amy.
Yeah, I agree with Joe. We should be talking a lot less about notice and choice. I mean, everyone agrees that that's not the most important way to protect consumers. I'm much more concerned with things like purpose specification. So what really has driven the internet, more than advertising, is the fact that you didn't have to know in advance what purpose you were going to use all the data you had for. And abstracting beyond the GDPR or California, I think one of the essential features of the American approach has been that, just to use a tried but true example, Google collected a lot of search data and then discovered that there were a lot of other potential uses for it, like predicting flu outbreaks or unemployment on a very hyperlocal level. There are a lot of things like that have nothing to do with advertising, that we potentially end up restricting if we say that you have to specify the purpose for which you're collecting data up front. Or, similarly, that you have to minimize the data that you're collecting because we know that there won't be any beneficial uses out there, right? There are many real-world examples of where that kind of approach breaks down. The most poignant one to me is the example of Vioxx, which it was discovered several years too late, was actually the leading cause of death in the United States that explained a spike in the death rate. And as I understand it from health researchers, it would have been possible to identify that trend years earlier had it not been for the rules that covered health data. Right? Now, I'm not saying that makes privacy regulation bad. It just means that we need to take into account that there are these real-world trade-offs and think very carefully about limiting purposes, requiring overly specific specification in advance, and requiring people to minimize their use of data for those unanticipated serendipitous discoveries, whether those are beneficial inventions or discoveries of trends, of things that might be bad, that we should do something about.
Grant or Amy, does anybody here share Commissioner Phillips' concern that significantly new privacy regulations are a barrier to entry for new firms?
Absolutely. So, Joe, to address one or two of the things that you said, the concern about startups that are, collecting information just wantonly or whatever, I think is, well placed. We don't want people just collecting data for whatever they may feel like. Being able to predict flu trends, et cetera, in the future is obviously something that we want to encourage as a public good. You can find out where flu outbreaks are going to happen earlier. In the case of advertising, though, our inability sitting here to predict what the next entrepreneur is going to create, as long as people use it, should not detract us from creating a situation where they can flourish. And a situation where you have opt-in consent just to do something as innocuous as targeting ads, that is, showing somebody an ad that you think they might be into, is, I think, probably going to significantly curtail the useless apps in the future, the fun apps, the entertaining apps, the things that people use to waste time, as well as some of the ones that may turn into something very valuable, like predicting flu trends.
Amy?
So Berin and I have been fighting about this issue for so long that I know the flu example he used from him using it before. The reason I bring that up is because this competition argument is not that old. In fact, it really only started being used regularly when the GDPR was just about to go into force. We started hearing companies say, this just entrenches the major companies. We weren't hearing that when the GDPR was being debated at all.
Your point is?
Because now we have privacy and we have the threat of privacy coming into the US, there now becomes this idea, and competition is a big issue right now. There are a lot of headlines about competition and entrenchment, and in fact, when competition got brought up, I actually wrote down and showed to Joe what competition. Because where are you going when you get off Facebook? There aren't major competitors out there. Now, the funny thing is when there's regulation put into place, there's always going to be growing pains. And we talked about how large companies are able to handle those better. The commissioner did. I definitely read this morning a story about how Facebook, in discussing their precipitous drop in valuation recently, said it was because they're putting so many efforts toward privacy and security right now that they're having to divert them away from other measures. So even the large companies seem to be feeling this, if not at the same level, pretty close to the same level as the small companies. What is more concerning to me on competition, where I come into this, is competition tends to preference the first out the gate. The very first company that comes out the gate and offers a service, people will flock to. Once you get a number of people on your service, they become entrenched to your service. It's harder
like
for them
MySpace
to go
was,
somewhere
right? Yeah.
else. The reason companies are able to get out the door quick is because they ignore privacy and security. And so the companies that do well on privacy and security, that invest more time and more effort, they're slower. They're not the first out the gate. They're the second out the gate. They lose the market share, and those companies fall by the wayside. If we were to level that playing field and give companies that invest in privacy security a chance to be the first out the gate, I think we'll start seeing a lot more users being able to have their privacy be protected in services that we all use.
If we deviate from harm-based and go to this more fundamental right to privacy, does that mean that it's something new that the U.S. needs to create? Because as you know, there's no U.S. constitutional right to privacy. I think there is one in California's constitution. But is it necessary to create a right to privacy in order to be sweeping enough to cover all forms of data and not just harms?
I don't know if it's necessary, but I'd support it.
I don't think substantially increasing the cost to start a business is a way to go about telling them that they have to focus on privacy and security. I mean, MySpace didn't succeed probably because Facebook offered a better product. Facebook's concern about privacy on the earnings call, personally, I think was a bit of a red herring. I think they ran out of users on Earth. They ran out of user growth numbers to support it. I don't think it was nearly as much about privacy as they'd my friends.
But they had an absolute decline in the U.S. and Europe. Their richest users is only a third of their base, but they had an absolute decline, not just a slowing growth. So the privacy backlash, the techlash, is definitely having an impact. Berin?
I just want to respond to a few things quickly. So first of all, this argument of competition, this is not new. I would encourage you to go back and read the 2010 paper entitled Opt-in Dystopias by Betsy Masiello, who...
And I don't want to say it's brand new, it's just not been
Well, okay,
prominent.
I've been making this argument for a long time, and so have a lot of other people, and they've been pointing out, again, this is very basic, very intuitive, right? That bigger companies are better able to deal with compliance costs, but more importantly, they're better able to get consent, to negotiate, because they're the ones that have the existing relationship, and they're the killer apps, if you will. They're the ones with whom individuals will say, sure, I'll sign on to that, which leads to the second point that they raise, which is desensitization and then the excessive scope problems, right? These are well-documented problems that are attended in any opt-in regime. So we have to be realistic about those problems. I want to push back against something you've been saying, Steve. The US approach is not just a harms-based approach, right? Section 5, yes, in part, is
Unfair
about
deception.
harm, but it's also about making sure that consumers get the benefit of the bargain. So deception, for example, one of the biggest misconceptions about the FTC is that you have to prove harm in a deception case. You don't. All you have to show is that consumers were promised something and they didn't get it, or that there was a material omission, that someone reasonably have expected to know about something. In other words, the FTC's approach right now is a lot more flexible than people give it credit for, and it's able to go after situations where there is no clear proof of harm. So what I think the US approach is better referred to as that there is a comprehensive vehicle that addresses what I've just mentioned, which is really grows out of advertising law, but marketing more generally, deals with harm in that respect, as well as these other concerns. Now, as to this last point about startups, right? I think we really genuinely do want startups to be able to succeed. And of course, we also want them to be responsible. But you can't expect every company out there to have a data compliance operation like Microsoft's ready on day one. And there's a certain set of players right now that have that mentality, right? I use the example often of how many people here have ever tried to implement or have ever used Microsoft SharePoint? Right? If you know anything about it, it's a great tool for a really big enterprise. It's really complicated. And I made the mistake of trying to actually get my small organization, TechFreedom, on that years ago, only to discover that it's insane for us to try that. We're much better off just using Google Docs, which does 90% of the same things in a much simpler way. And my point is that big companies can handle an internal data compliance set of controls that is basically akin to SharePoint. It's fine for Microsoft, Google, or Facebook, or Amazon. But we start talking about, it's not just startups, it's the GDPR applies to everyone, essentially every company in Europe or any other company anywhere in the world that holds data about Europeans.
Right.
We're talking about butcher shops, right? So this is the entire ecosystem. We need a system of regulation that works for everyone, not just the biggest companies. And then the final point, look, we don't know why Facebook just lost 19% of its valuation, right? We know that the earnings are down and so on. We don't know what exactly is driving that. But my hypothesis is it can be both things. GDPR can hurt Facebook and Google, but still in relative terms favor them, right? And so we could actually see that all these companies suffer, but other companies suffer more. Okay. And I'll give you one final example, which is Spotify. I looked at their earnings report that just came out a few days ago. They, too, are saying that they're losing users because of GDPR, that they're having to devote a huge amount of their internal resources to GDPR. And small companies, they may spend $600,000 if you're a small company to get your online video game comply with GDPR. That's a situation my colleague dealt with recently. That's real money and real engineering time that's being diverted, and those have real effects.
But don't you think that cost is going to go down as we figure out GDPR?
There's
a lot of costs right now.
It may or may not. Some of the costs, yes, are upfront costs. You're quite right. But other costs are totally dependent upon what the approach taken by each of the DPAs is. Right. And we just don't know.
Yep.
So
And we're going to open up for audience questions in just 5 minutes. And it would be great, though, if I could get the panelists to respond to something other than GDPR. But at the same time, it's something that the Europe's approach to privacy is likely to bring to our shores. And this notion of another right, called the right to be forgotten. This notion that if you find information about you on the internet that is, in your opinion, irrelevant, that you can petition to have the search engines never show it to people that search your name. This notion of right to be forgotten is in front of the European Court of Justice for potential application here. And I'd just like to know whether you think, does it smash headlong into the U.S. First Amendment protections if a government is doing it? Does it begin to affect the U.S. ability of consumers to know who they're dealing with, of employers to know who they're hiring, businesses to know with whom they're partnering? And do you believe the right to be forgotten is on the list of European rights you want to import to the U.S.? We'll start with Joe.
So first, because I have to correct this because we all do these privacy sessions and have our talking points. The long extenuated conversation about Google flu trends is worth acknowledging. The Google flu trends actually didn't work. It was broken. It was inaccurate. That's something that this great, tremendous, innovative benefit of Google flu trends should be pointed out to everyone. But I just have to say that. Back to the right to be forgotten. So I don't think anyone on this panel is going to be a fan of how the Europeans have understood the right to be forgotten. That said, I think users should have some right to be able to delete, pivotally to be able to port and move the information that they provide to platforms and services. That said, it becomes a really big problem when we're asking a company to make really important free expression determinations on behalf of society. That's where I think deletion rights become really problematic in data protection. That's worth acknowledging. That said, the tone and tenor of your question basically seems to suggest that, like, my concern about how the right to be forgotten can be implemented in, you know, the ability of people to access information via search results, that sort of gets bootstrapped onto, like, opaque data ecosystems. I think your question's also going to try and get at, well, then what are my thoughts about regulating data brokers and other folks like that? And that's where I think that's not necessarily a right to be forgotten issue, as, again, an incredibly opaque ecosystem that wants to use the right to be forgotten and the First Amendment as a shield about either cleaning up their acts or even basically self-regulating.
Yeah, opaque may not be good, but I heard you earlier say that transparency was a complete waste of time. Amie.
So a 60-second, hopefully, lecture on right to be forgotten. Right to be forgotten is actually two different rights. There's the right to erasure, which means if I no longer want to be a Facebook customer's the wrong user, whatever, I can go to Facebook and say delete all my data. I'm leaving your service. I don't want to be a customer of yours anymore. Delete all of my information. That is half of right to be forgotten. The other half that people focus on is the right to delist. I don't want Google to have certain search results come up when Amie Stepanovich is typed into Google. That is only half of it. And it's really important to separate those two things out.
Do you like either
At least
half?
from our perspective, because the right to erasure we think is absolutely vitally important in a data protection regime. You should be able to say, I am no longer interested in you having my information. I don't want to be here anymore. Because once you opt in initially, if I have to use something on my phone for 2 seconds, I download an app, they then have all of that data on my phone up until that point. If I use it for 2 seconds and then take myself off, I can keep them from getting more data, but I should be able to take that other data away from them as
And
well.
Amie, how does you and Access Now feel about the other half of right?
The
to
right to delist, we have an entire report on this, by the way. It's about 10 pages long. It's really pretty, bright colors. What we say is the right to, it really is, we have an amazing designer. The right to delist is not something that we support. If it is enacted, we give a laundry list of protections that would need to be in place with it, but we say it is not something that can be done without abuse. There are too many issues. It is not something that should be imported here. But it's important to have that entire list of safeguards as well. It's important to take those two things out and unpack them. And I highly recommend, if you're interested in the right to be forgotten, to read the report, because there's a lot of information that gets packaged up into this, like, don't take search engine information off the internet. And that conversation tends to be really shallow.
All right, right to be forgotten. Let's quickly cover that with Berin and then Grant.
Okay, question first for Amie. Do you think that the right to erasure should allow me to delete my comments in let's say a public Facebook thread on your page, or private messages with you? So
Private messages, potentially, yeah. Public postings.
What if it's something where you'd shared something only with your friends and I'd commented on it? Should I be able to delete my comments in that context?
I think you are able. I go to Facebook. I'm able to publicly delete my comments now.
Right.
I should be able to delete Facebook from having those comments too.
So-
But if, Amie, if I tagged you in my photo on my Facebook page, it's my photo. You can take your tag away by quitting Facebook, but
Well, yeah,
it's still
you
my
just described
photo.
the right to delist.
My photo. It's still my
The
photo. You can't
the right
take down
to
the
delist,
photo.
you can't take the content off. You can only take off the search result. The content
And
is
that
all
right
still
exists.
there.
That right exists today. If you take yourself off Facebook, the tags disappear.
Well, the right doesn't exist. The ability exists.
Berin
So-
and Grant,
yeah,
and then
so-
we'll move on to audience questions.
Yeah, I have very little say. So as far as the NAI is concerned, we don't have a policy on right to be
Okay.
forgotten. We just do privacy in the United States and self-regulation for digital advertising. Berin?
I just have a real problem with any system that allows people to sanitize the historical record. And you know, that happens all the time. People, as we've seen, especially recently, people may reveal their true selves and then try to hide that. You know, and we could have a conversation about how we should adjust as a society and realize people make mistakes and the opportunity for redemption. That's a good conversation to have. I don't think we should allow people to delete parts of the public record. Now, different point as to the other things you mentioned. I don't want the government to deal with this. I prefer that this be dealt with by the platforms. And as you note, they'll strike their own balance. But it's just as a purely descriptive matter, This right would not fly in the United States.
We shall see. Let's go to audience questions. We have about 15 minutes. Shane first. Microphone coming your way.
Thanks. Amie, I'm at the point in the day where pretty colors would really distract me, so I was looking for this report that you were talking about, and actually Access Now just tweeted about how important healthcare really, you need to be able to be connected. And one of the interesting effects of GDPR has been that there's a lot of actual challenges about security systems that are in DDoS. And if we were to have an attack on a system, one of the places you would go is in long history is the who is. So one of the things that we haven't discussed today in the importance of privacy is also, when we're blocking who's a natural person and who's a legal person, what do we do about the information that we need to have so we can make sure that if we go to 5G in healthcare and we need that constant service, that we can't find the person who's causing the trouble? And I realize I'm just pointing to you because I was looking for the pretty, I'm still going to look for the pretty report. But just to the panel, what do we do about the antithesis problem on this, which is not knowing who you're dealing with?
Yeah, so does the law limit the ability to get the information we need to protect consumers, for instance? Anybody want to respond?
This is just a really cheap answer. Our European office is our GDPR experts, to the extent there are GDPR experts, as you told me, Berin, earlier. If we were to do this approach in the US, as I said, we need to have a US-based approach, and I think we need to take that into consideration because we've learned on the back end of GDPR that there are some negative consequences there that we're going to have to grapple with. But I don't think that doesn't necessitate putting rights into US law. I think that is just an impact that we've seen that we're going to have to deal with when we look at a US approach.
So to me, this is a really important example because it illustrates how ill-conceived the GDPR really is. I mean, a lot of people sit down and say, oh, the European Parliament, they had so much work on, the Commission had so much work on this has been well vetted. Well, it produced this insane result wherein the basic mechanism by which cybersecurity is handled today is you see traffic coming to you from a particular site or domain. You want to see who's behind that. So you use the whois database to look them up. And GDPR had the absurd result of essentially making that information private. Right? That's nuts. And so when I said earlier that the GDPR envisions that these sorts of unworkable, crazy things will just be dealt with by the DPAs exercising their discretion to kind of make policy and just smooth out the edges. That's the European approach to writing laws. You don't care too much about their real-world applications strictly applied because they'll never be strictly applied. In the United States, however, laws get strictly applied. So if you take anything away from this example, it's that this is, I think, probably the tip of a larger iceberg of an approach to writing legislation that will not work in the United States and needs to be much better thought through.
If Amy's right, we'll learn from some experience on
Well, and
this.
just real quick to respond to Berin, there was a lot of disingenuous opposition to the GDPR. So had somebody brought this up in advance, I think it was well considered.
But you know, Amie, there is a balancing act. The GDPR says that these privacy fundamental rights have to be balanced with the legitimate needs and purposes of other requirements of law. So it's sort of in there, but it's impossible to know how that balancing act has to be done.
Precisely.
Well, and I think that there is a lesson here for doing this in the United States, which is if we all come to the table honestly and we're honestly flagging issues, we can honestly make sure that those are considered in the law.
I honestly hope you're right.
If people in opposition to data protection come to the table and have disingenuous, hyperbolic points, which happened in the California data protection debates long before the provision that got passed ultimately was even drafted.
And I think you'd
You're
share
going
that
to
the
have-
hyperbole was on both sides, right? You would agree.
I think this is the most important thing we're discussing today because what we're talking about here is there's two modes then of, if you will, making law. One is the legislative process where Amy's saying we need to make sure that the concerns get addressed so we can be specific and clear about them in the law. Fair. But everyone knows that's not, the legislative process is not the end of lawmaking. Laws continue to get made and shaped after that. And my point is that if you simply leave everything up to the discretion of the regulator and say, don't worry, they'll figure it out, they'll work this through, that creates an entirely separate set of problems of not having clear guidance, of favoring the bigger companies that can navigate that uncertainty, that can manipulate and lobby and capture the regulators, and then there's another final dimension to this, which is the more discretion the regulators have, the more room there is for politicization. I mean, what do you think, imagine if just for a moment, if we had a data protection authority in the United States that were not an independent agency with a bunch of case law to constrain them, and instead had a head that was appointed by the president. I guarantee you that that person would be very carefully chosen by the White House. And the question that was asked of that person would be, so you're gonna be loyal to me? When I call on you and I tell you to screw Jeff Bezos, you're gonna do it, right? And they'd say,
Okay.
yes, sir, absolutely. And this is not a fake concern. This is the kind of concern we have to deal with now, that these platforms are subject to enormous political pressure. We have to recognize that privacy, the discretion in the enforcement of privacy regulation will be used as a political cudgel, and so we have to be careful about how we stack the deck and how much power we give to government to extract against politically disfavored companies.
And that could happen today with the
It could.
FTC.
We don't even have to pass a
Well,
new
the
law for
FTC
that. The FTC's words are unfair and deceptive trade practices.
But however, the
There's
FTC
a lot of
has
discretion.
some important safeguards, and importantly, the FTC has to actually prove its case. The defaults matter. If the default is you have to justify what you're doing, it's a lot harder to politicize your agency.
Good enough. Let's go for some more audience questions. I have this gentleman over here in the white shirt.
Hi, John Perino with George Washington University. Thank you for the afternoon fireworks, first and foremost. But at the end of the day, it does sound like everyone on that stage kind of agrees on this middle ground. So if we kind of put the US at a 1 to 10 scale at a 1, and the US GDPR on a 10, do you all agree that we should be somewhere with the US-based approach on a 5?
No.
No. I don't believe in a middle ground. I believe in a not EU GDPR ground. I don't think it's this. I think it's more three-dimensional.
All right, we'll go to another question. Nathan?
Yeah, so I think this would actually be a good.
No, she's got it.
I sort of have a different approach to a similar question. And also agree, thank you for keeping us awake on a Friday afternoon. This is a surprisingly passionate topic.
Surprising.
NTIA and Department of Commerce are looking at what they call the formulate core high-level principles on data privacy. The administration is looking into this. GDPR exists. The California privacy law does exist. We are talking about something at a federal level. So assuming all of the people in this room and at least on stage are going to talk to the Commerce Department as they formulate their high-level principles on data privacy, what is it that you are going to be telling the administration that they should be considering, thinking about, and recommending?
We'll start with Berin and move down.
Look, the Obama administration really struggled with this. It took them 3 years between putting out their set of principles and their legislation, which of course never went anywhere. And that reflected the work of a lot of really bright people who really had thought this through. I don't necessarily agree with all of them, but that approach reflected a well-developed bench. Unfortunately, the bench on the other side is not, it's not well-developed, in part just because of the US approach has not been systematic, and that is a deficit, right? So what we really need to do is to abstract, just as the Obama administration did, but then to try to be more concrete about what operational realities will look like. So my short answer is, I'm going to be very focused on concrete examples. And I'll just give you one, lead you with one, which is that, to me, the most disappointing thing about the LabMD case, which is, of course, the FTC's first litigated case on data security on the merits. The Wyndham case didn't finish getting litigated. The most striking thing about that case is when the whole thing finally went to trial, after going to the administrative law judge, the FTC put up its expert witness and was saying, you know, here's what we think the data security should have been with regard to the installation of peer-to-peer file sharing software. That witness could only speak to the data security practices of Fortune 500 companies. They had nothing to say about a company like LabMD with 25 employees and I think $10 million in revenue. My point is that kind of level of granularity is what really matters. How do we make sure that the implementation takes into account local circumstances? Could there have been a framework that LabMD could have signed on to? Maybe it could have been blessed by the FTC, right? That's what I'm going to be focused on.
Okay. Grant, what would you tell NTIA?
I think first, a carve-out safe harbor opportunity for self-regulatory programs with any sort of teeth, backing, et cetera. For example, a strict requirement for how some types of data are allowed to be used, not allowed to be used. For example, sensitive health information. Those sorts of things we can generally agree. You shouldn't be receiving, for example, the NAI prohibits the targeting of ads based on someone's perceived sexual orientation without their opt-in consent. We receive calls every month from people with legitimate interests in wanting to advertise to who they perceive to be people interested in their, say, gay crews, et cetera. They're upset because they feel they're being discriminated against. Our position has been that no one should be outed by an ad. So things like that, I think, built into intelligent, proactive self-regulatory harbors, depending on industry, scope of the problem, et cetera, are smart. The NAI recently announced and released our TV guidance. So we're up to speed on how data collection is happening on smart TVs. It's another small example of how a self-regulatory harbor provides an opportunity for people to react quickly and I think get a little bit of the best of both worlds.
Amie?
So I know that we're at time, but I promise I'll buy you all a drink in the reception afterward if you stick around for a couple more minutes. This is actually a really manipulative question for Nathan because I'm about to leave on vacation and we work together, which means I'm sitting up here giving him advice on what to do while I'm out of the office when the Department of Commerce comes calling.
Nathan is nodding.
We also already had the meeting with them.
I think that there are two things here that I'll emphasize. One is principles, from our perspective, I don't think are going to be enough, but if they're going to be principles, they need to look at what more needs to be in place and where we should be having affirmative rights. The second thing, Berin brought up LabMD, which I think is really interesting because you brought up a 25-person operation. And in my experience, a 25-person operation or a 200-person operation can equally impact the information of 2 billion people. And so there is a need to look at not only the size of the company, but the size of the database that they're bringing in, and make sure that the protections are in place to deal with that. Because I don't necessarily want Joe Schmo company handling my electronic medical records, which came up earlier, just because they might compete with some other company that can do it a lot better.
Joe?
All right, 3 quick things. Steve, you were digging me for my hyperbolic statements about transparency, and what we have conveyed is that transparency for regulators should not be equated as transparency for users. Unfortunately, the way, again, we operationalize things through privacy policies ensures that these things get conflated in a way they shouldn't. So, when we look at things like Facebook and Cambridge Analytica, but also recently the Strava heat map, or the fact that Venmo, which is a financial social network, is basically by default putting out all sorts of public information about your financial transactions, our thought is that transparency to users really needs to incorporate elements of design and UX experience, and that increasingly companies deploy these sorts of things in a way that is manipulative and desirous of as much data as possible. Second, FTC rulemaking authority. Berin and I might disagree here, but the Magnuson-Moss procedures don't work. If we're going to be expecting the Federal Trade Commission to be doing data security rules, data protection rules, it shouldn't take 18 processes and 5 to 10 years to actually get into place. And then I mentioned this earlier, again, enforcement. Since the beginning of the FTC's privacy work, they have taken what were a pretty detailed set of FIPS, and that's the first time we said fair information practice principles on this panel. But it took all of these principles and condensed them to notice and choice, and then ultimately just notice. And one thing that was really missing the entire time is enforcement. And by enforcement, we're talking about actual penalties and the ability to sort of actually hit companies with a stick.
I can tell Berin's upset.
mission
Last question, though. We have
200
to.
cases.
I know, but we have to. One last question, and then we're out of here. Make it quick, please.
Yes, sorry. Jonathan Zook, Innovators Network. One comment, which is that we've talked about GDPR being like an impetus, that now it's time for us to do this too, and yet when we talk about something like ability to be forgotten, well, it's not time for us to do that. So I guess I want to pause on the notion that because it's happening in Europe, it means it's time for it to happen here. It might be time to watch how they end up handling it and how European companies actually end up handling the regime that's sort of being put in place there before we leap on board. But the other thing I wanted to address quickly was the competition issue. is not just size, but also business model that comes into effect as well. And one of the most egregious examples was, in fact, a settlement that the FTC reached with Google, having found that Google had misbehaved and misused data. They reached a settlement that dealt with sharing of data with third parties, so that the settlement and the resulting sort of precedent that was set is that you shouldn't be able to share certain kinds of data with third parties. And in the case of Google, because they're vertically integrated, there wasn't any third parties, and it was only small businesses that by definition, through their business model, have to share with other parties that were affected. So Google, by behaving badly, was able to achieve a settlement that did not apply to them, but in fact affected anti-competitively their smaller rivals.
All right, in fairness to the panel, do you guys want to each, you have a 15 seconds, final word. What can you do? Should the U.S. emulate some of the European privacy approaches?
I mean, it already is. Companies are going to be moving toward that model anyway. For us to continue to say that the tech space in the United States should go unregulated is just untenable. We can continue to do that, but if you want to be a global company, and presumably all of these innovators are moving toward that way anyway, they're going to have to lose.
Already is your answer. Amie?
The time for data protection in the U.S. was 20 years ago. GDPR just means that we need to, it's going to happen. I think now it's just a matter of what's in it.
Okay. So we're already late.
If we adopt something, adopt a scaled approach to sensitivity of data and how you use it.
And Berin.
There are, according to Jerry Stegmeier's count, 140 laws in the United States that regulate data in one respect or another. The data ecosystem is already heavily regulated in a variety of ways. It's a mistake to call it unregulated. The European fixation on comprehensive systems biases this debate because everyone likes to talk about a simple across-the-board solution. The United States has a lot to build on. It can always be improved because it's an iterative approach, and we should continue to iterate it.
Fantastic. Please join me in thanking the panelists.